morning. We are here for oral argument on Jamie Clem versus Pinal County / Teeple. It's our number CV-25-0313. I believe both the council know you each have 20 minutes. Mr. Abney, keep whatever time you wish for rebuttal. Keep the time yourself. Please proceed.
May it please the court, my name is David Abney. I'm representing Jamie Clem. In thinking about rehabilitation, I came up with two great examples, one fictional, one historical. Probably the best example of rehabilitation was Saul, who was on his way to Damascus to arrest the Jews there who were worshiping the Christ. He was hit by a blinding light, knocked down, and 3 days later, after fasting and prayer, he is truly rehabilitated and becomes the greatest of the apostles. But that sort of miraculous thing doesn't happen in courtrooms. What we have is something called rehabilitation, but nobody defines what rehabilitation means. There's all kinds of synonyms. You could be reclaim, redeem, reform, cure, fix, mend, and heal. But nobody tells us what it really is. They say, well, we're going to rehabilitate this juror who has indications of bias or prejudice or loyalty or all three. But nobody says how you're supposed to do that. And the first issue the court presented was, may a trial court rehabilitate a prospective juror challenged for bias, prejudice, or loyalty to a party solely by asking whether the juror can be fair and impartial? And my answer to that is no, you can't do that. I don't think you're going to rehabilitate a juror at all. Under any conditions, you can, not in a few minutes. A rehabilitation takes time. If you're truly going to try to change somebody's viewpoint on something important about a person that they have a bias for or a prejudice against or a loyalty toward, you simply cannot eradicate that in a few minutes or nullify it. And I don't know why we have thought for so long that we can. We simply can't. I cited a bunch of studies about this that politely say it's just a bunch of bunk. And I think it is. No questions on that point so far? Okay. The second question is the appearance of the denial of the right to an impartial jury as a result of seating a biased juror sufficient to require a new trial without showing prejudice? I don't know how you show prejudice in a situation like this, where you get somebody on the panel who has evident bias, prejudice, loyalty, great loyalty to a party and to the party's in-court personal representative.
So, counsel, let me ask you a question about that then. Maybe we'll go back and talk about rehabilitation too. In this particular instance, to show prejudice, and I want to frame the question this way, to start with a preliminary question. When information about Juror 6's posting on Facebook, a campaign photo came up, and the court inquired into that, was that an inquiry into the juror's bias, or was it an inquiry into juror misconduct?
It was both.
Well, no, it makes a difference which one it is.
Well,
Because the court's just not going to generally inquire into a juror's bias at that point, because that's what voir dire is for. So at that point, if you're going to bring it up to the court with that as evidence, and I guess I'm suggesting the answer to the question, isn't that really an inquiry into juror misconduct?
but yes, with an explanation. And I think, I really do think it can be both. Certainly it was an inquiry into misconduct. He wasn't supposed to be posting anything about anybody related to the trial while the trial was ongoing. So that's bad, and he should go for that reason. But it's also further evidence of what was fairly apparent during the original voir dire, that he had that bias. So it just nails that down.
Well, and so the reason why I wanted to start with the misconduct is then to be able to address the question about showing prejudice. If you have juror misconduct then, and the court has wide discretion to inquire into that and to conduct an investigation, wouldn't it make sense at that point then, because a civil jury can begin to talk about the evidence in the case without forming a conclusion prior to actually being discharged to deliberate? Isn't then the inquiry into whether or not there's prejudice, the effect or possible further behavior by that juror? So in other words, let me try to boil this down. You got an inquiry into juror misconduct. The misconduct suggests that there is a degree of juror bias greater or more substantially than was shown during voir dire. Isn't that where then the party affected by the juror can inquire into what happened in order to establish prejudice?
There could have been more discussion about that, but he did admit that he had discussed his predilections toward Teeple and Lamb with the jury, and they didn't go any further in discussing that. And from the comments that I was reading in the transcript, it looked like there was a great deal of concern about Rule 606. How far can you go? If you read Rule 606 carefully, it doesn't appear like you can go very far at all.
Well, and on that point then, Rule 606 gets into a verdict. We don't have a verdict yet. So I question whether or not Rule 606 is really applicable at this point, because it has a specific temporal nature to it. And the inquiry into a juror's thought processes, the mental deliberations, mental processes for deliberations, that all is with respect to discussing the verdict. This might be a bit of a gray area, but couldn't we say that in order for a party under these circumstances involving a civil jury to be able to demonstrate prejudice, you're allowed to inquire into whether or not whatever information the juror in question may have shared, could it affect the other jurors' abilities to continue to render a fair and impartial verdict? We aren't in 606 land yet because we don't have a verdict yet, and the jurors aren't supposed to get to a verdict yet.
Yes, you have a great point there. But the parties were looking, and the judge they were all looking at this as if 606 was the applicable rule, and that's the rule that they followed. Whether it should have been followed strictly or not, I don't know. It seems to me like it was enough that in this particular situation, they were also concerned about the inquiry into what the jurors were thinking and what had passed in the jury room that they just backed away from it entirely.
So if we do agree that, or if we conclude that 606 does not apply, and as defense counsel, plaintiff's counsel, and apparently the court all agreed, under state v. Code and other cases, the trial court should conduct an adequate investigation into juror misconduct. So if everyone was misapprehended the law and they could have gone forward, what is the consequence of that error? Is that abuse of discretion on the trial court, which inures to the benefit of the plaintiff here? Or is that held against the plaintiff for failing to press the trial court?
I think it's such a fundamental error in the interpretation and application of the rules you would use de novo review. But even if you talk about abuse of discretion, what the trial judge did on the fifth day of trial was not so bad, at least in the sense of getting him off the panel. He should have never been on. But in not declaring a mistrial, there's the big problem, because the appearance of prejudice at that time was severe. You've got this guy on the panel right from the very start. He's having discussions with other jurors. You're never going to know exactly what happened. Putting a shine on the apple as far as Teeple and especially the defendant, that creates such an appearance of impropriety that anybody looking at this would be going, well, how can you have a fair trial? You've got this guy on the panel, he's allowed to have discussions with other jurors. He admitted he had discussions with the other jurors about his viewpoint on these two, friend and good friend of his. How can you say that there was ever a fair trial at that point?
Well, we have our Constitution, which says that we don't reverse for technical error in the pleadings or proceedings when upon the whole case it appears that substantial justice has been done. So, to me, that at least says you need to have some kind of prejudice shown. And I completely understand your point, the difficulty in showing that kind of prejudice in this scenario. But that tells me we don't simply go on, an appearance. We have to, can you help me in drawing the line of what you do have to do in a situation like this? What type of an inquiry needs to be made to see what type of statements were made or outside information brought in by this juror that might have biased this jury?
I think it's enough if you get that biased, prejudiced, loyal jury on the panel. The bit about in the Constitution and in Rule 61 about we don't reverse for technical errors, this isn't technicality, this is substance here. We're talking about your right to a trial by jury, and with it is the right to have a trial by an impartial jury. And here we've got evidence that it's not an impartial jury. you've got juror number 6 who is as partial as you're going to find. In fact, if you talk this over with anybody and I get the same reaction, how could this happen? After oral argument, we had oral argument at the Arizona School for the Deaf and Blind, and a teacher gets up right at the end where they start to ask questions. And the very first question he says, how could this have happened? And the judges say, well, you can't talk about the merits of the case. But I was talking with a friend of mine in Ore City, Texas yesterday, and I described this. He said, how could that happen?
Well,
That would be extraneous
Yes.
what you're saying sounds like structural error to me, that that every time a juror is found to be biased and released from duty, that in and of itself is enough to say then there was not an impartial jury that was convened there for mistrial. I mean,
Not just
is
biased.
that the argument?
Close, not just biased and released from duty, but biased. It was evident on day one he was biased. And asking him 10 times, can you be fair and impartial despite this, that, or the other? That's just compounding
Aren't
the
you
error.
extracting that principle from a line of cases that involve a partial juror remaining on the jury through verdict? I understand that if you had a partial juror who was on the jury and participated in the rendering of the verdict,
All the way to the end.
then that aren't you extracting that principle and applying it here where the juror is removed before deliberations and rendering of the verdict?
Yes, to an extent. He didn't make it all the way, but he made it through 4 full days of being around the other jurors when they're allowed now to chit chat about the case. So you don't know what's going on during that chit chat. I mean, is he talking about my good friend? We did discuss to some extent his friend and his good friend and the people that he had donated money to and supported on the internet. I mean, it's just a horrendous situation that this guy gets on the panel to begin with.
They had heard that, though, in voir dire, regardless. They'd already heard him say that, I assume they're all in there, and heard him say, yes, I know the representatives, people, and I know Lamb, and this is how I know them. So they already knew that. Does that make a difference then?
No.
I mean, the judge seated him after that knowledge.
No, I think it's one thing to have this very carefully, tightly controlled colloquy during the voir dire, and another thing to let him loose in the jury room, and you don't know what he's doing, what he's saying, other than we know he had discussions. And perhaps there should have been more of an inquiry into that. The parties and the judge were concerned that they couldn't do that.
Well, and again, if I might, one of the reasons why I'm drawing that distinction between voir dire and then the subsequent investigation into misconduct is because what we don't have in our case law is the ability to conclude bias. And the juror wasn't dismissed for bias. The juror was dismissed for appearance of impartiality. And so that impartiality, that's called into question as well. Because it's not clear if the judge was looking at simply the misconduct in question and then deciding that now I have an appearance of impartiality, or somehow that was in conjunction with voir dire. And it seems to me that the dismissal of the juror after the posting of the photo on Facebook was not a remedy for the failure to remove the juror and not seat them to begin with. Rather, that was simply the conclusion as a result of the inquiry into misconduct. I think it may be important for us to keep that distinction, but
Sure.
if I'm wrong there, please.
Well, I don't think you're wrong, but maybe you're being a little imprecise. I think that what happened on day 5 was that a biased juror was finally thrown off the panel for the misconduct that confirmed that he was a biased juror.
And that's the point I wanted to clarify, because if we're looking at the record in the trial court's decision, and it's an abuse of discretion standard, how do we look at what the judge decided with respect to the misconduct and impute to that judge then it was a makeup for not doing the right thing during voir dire?
I don't think you can, if I understand this correctly, I don't think you can make up anything at that point. I think the damage started on day 1. And at that point, when you put juror number 6 on the panel, you had a partial jury at that time. You had the jury poisoned by having him on the panel. And I don't think you can get rid of that appearance of impropriety later on by tossing him off the panel on day 5. You went through this entire trial with a panel that I believe any objective observer would say was not impartial because you had juror number 6 on it, when he clearly expressed bias, expressed bias and loyalty, a great deal of loyalty, to the sheriff, to his in-court personal representative.
Let me ask you a question about the loyalty point. In Eddington, it discusses loyalty and interest. Why isn't this a 21-211-2 case? Why didn't the plaintiff raise that as a point? That what was going on here was that you had an interested party, not a biased party under 211-4. Because if they're interested, Eddington would say that they are disqualified from the get-go, and you can't rehabilitate an interested party. I see the argument there.
Right, but the 12, I have my cheat sheet, the 12, ARS 21-211, subpart 4, talks about persons biased or prejudiced in favor of or against either of the parties.
Right. But
He should have never gotten on the panel under that.
But in the distinction I was trying to make with you is you mentioned loyalty.
Right.
I see that. Loyalty is discussed in Eddington as
Right.
interest. Why isn't this a 211-2 case instead of a 211-4?
No, I think it's 211-4. I think.
Well,
Well, could it be that under two,
It could be both.
persons interested directly or indirectly in the matter under investigation?
Right. It's not. That's not really what. I don't think that's really what this is. I
but the
think this-
statute doesn't make a differentiation. I mean, they're disqualified whether they are 2 or 4.
Right. And four seems very emphatic and right on point. Biased in favor of a party. He's biased in favor of the judge. And of course, Lieutenant Teeple gets into the mix. He's a very close friend with him. In fact, he's so much in the mix that when the court announced the case, Teeple's name appeared somehow in the caption.
What do you make of the fact, though, that Teeple and Lamb were not witnesses in the case? I mean, the point was made, dealing with, for example, credibility of a witness. Teeple was the representative, the agent of the defense. So how do you respond to that point?
Your Honor, I got the first part of your question and then I forgot it. What was the first part?
No, just the point that they were not witnesses in the
Oh, yes.
case. In other words, we're not dealing with the credibility of a witness.
Right.
Now, I understand Chaplain Whitaker was a witness in the case, and I know that has not been emphasized, but sounds like he this juror had a relationship with the chaplain as well. But to the point altogether, we're dealing with Teeple and Lamb. We're not dealing with the credibility of a witness, but more so the credibility of a side, of a credibility of the defense side.
It's not so much credibility here. It's that Lamb is the defendant. That's the sheriff. And the sheriff's personal representative in court every day in uniform is right there, Teeple. It's because they are there and you have a juror who is a close friend of one and a friend of the other and donates money to them and lauds them on the internet. That creates the appearance of impropriety. That's an evident showing of bias. Eddington added on loyalty, which isn't technically in the statute, but it's a necessary, I think, corollary to the rule, a necessary way of applying the rule. I'd like to retain some time.
I think this is a good point.
All right, thank you, Your Honor.
Thank you. Okay, Mr. Jellison?
Good morning. May it please the court. My name is Jim Jellison, and I represent the Pinal County Sheriff. Mark Lamb at the time, Sheriff Teeple now. I think that anybody, judge, attorney, who has done more than a handful of trials in their career know that just about every prospective juror that walks through that courtroom, those courtroom doors, has some bias and prejudice. And in that mix of bias and prejudice, there is an awful lot of bias and prejudice related to issues in the case, whether it be the process, whether it be the underlying facts, whether it be damages or any of the myriad of issues that are tied into a civil jury trial. We also know a few other things, that voir dire is awkward. I've never seen it not be awkward. And I would add to that Judges and lawyers who do it really skillfully, I would say, are probably in the minority. But imagine bringing all these jurors in here and starting to ask them personal questions from lawyers and judges that they've never met. So we have a long history of cases that say, listen, we know that. We know it's part of an imperfect system to have jurors. But the way that we handle bias and prejudice, number 4 on 21-211, is we talk to them to determine if those biases or prejudices are going to affect one of the parties in this particular case in a way that disqualifies them as a juror, makes them unfair, makes them partial to one side or the other. And that's why we do the voir dire. And I think it's appropriate to do so, but I look with a little bit of amazement at what I see in my colleagues' writings. On page 5 of their supplemental brief, Arizona should abandon judicial rehabilitation in favor of identifying any bias, prejudice, or loyalty to a party, and then refusing to impanel prospective jurors who have those characteristics. That's going to be a game changer in the selection of jurors if you were to go that route.
Well, I think the concern more is how far should the judge go? And this is, I believe, at least one of the first, I guess not the first, but one of the first cases that we really will be addressing that. Now we've eliminated peremptory strikes. It's important that you get it right on how to strike someone for cause. And we have said that courts should no longer be asking those kinds of questions that despite everything you've just told us, you can be fair, right? I mean, we all know, as a matter of common sense, most people view themselves as, yes, of course I can be fair and impartial. It would be saying something derogatory about yourself if you said, oh no, I can't be fair. Most people just aren't geared to that. I read that transcript, and Judge Giorgini, who I admire as a judge, repeatedly asked that kind of thing, not only of juror 6, frankly, but of all the way down the line with any questions, and right out of the chute. I know that in this juror number 6, that you, as you point out, there was a little bit more fulsome back and forth about, well, put yourself in a plaintiff's shoes. What would you think? That kind of thing. But is that enough at that point? I mean, at that point, he's already gotten the juror to say, of course I can be impartial and fair in this case. I mean, that was right out of the gate. To me, then start following up with, well, but wouldn't the plaintiff feel badly? Well, they might wonder, but it's okay because I can be fair. Is that enough?
I think the question, as the court posed it, my colleague and I agree on, is it enough to just ask a question and get an answer? I'd like to see more furtive voir dire in cases than that. On the other hand, I balance that with some of the cases that I've seen from our own Court of Appeals, from your court, that have looked at questions and answers in serious criminal cases with much less beyond that, and have said that's not abuse of discretion. The judge was there, asked the question, got the answer, and saw the affect, saw the body language, and determined that person was sincere. And we
But
best judges
is that body of law from a time when you still had sort of the option of the peremptory strike? If you disagreed with the judge and you read the body language differently, you could strike that juror?
Well, I hope I read State versus Montoya correctly, but I read State versus Montoya as this court saying that we know we eliminated peremptory challenges. We took that bold step. But that doesn't change the rules of jury selection, and it does not alter the abuse of discretion standard that we apply when a judge denies a for-cause challenge.
How about as an alternative to Mr. Abney's bright line rule about prescribing judicial rehabilitation when there are indicia of bias, to a bright line rule that a potential juror who identifies himself as a friend of a party and a close friend of the party's delegee who's sitting there as the face of one side of a case should not sit as a juror under 21-211 for or otherwise common sense. I'm having a very difficult time understanding. I've conducted many voir dires as counsel. Any indicia generally of any affiliation raises a red flag. I have never seen a case where someone describes themselves as someone's close friend or a friend of a party and then is discovered to have effectively campaigned for them during active campaigns and have anyone with a straight face contend they should remain in the pool and sit on a jury. I think this is extraordinary.
I don't think it's as extraordinary in light of the decision in the Hill case, where being friends with the prosecutor, being friends with witnesses, that was not enough when the juror was able to answer questions to show that they could be fair and impartial. So I do have some disagreement with that.
Well, there's the fact that the statute refers to party. It doesn't refer to prosecutors, doesn't refer to witnesses.
I still think that there is no, I mean, if I've looked at the statutes, I've looked at your rules, and there are categories that are included as no-goes. You can't be on the jury. What you just described, Justice Lopez, is not in that category.
Counsel, let me take off where Vice Chief Justice asked a question. We said in Eddington that a primary purpose of 21-211 is to promote public confidence in the judicial system, and that everyone participating in and observing a trial should have confidence that the trial is fair in all respects. If the jury had consisted of 10 or how many jurors in a civil case, juror number 6s, do you think that the public observing this trial would have reasonably perceived that the plaintiff received a fair trial, given that juror 6 stated that he was a personal friend of then Lieutenant Teeple?
Your Honor, you bundled a couple of concepts into one, so let me make sure I answer this clearly. Because juror 6 was not involved in the deliberations or the verdict in the case, then I don't think that
But 211 doesn't require that, and I told you what we stated in Eddington as what the primary purpose of 211 is. So, given those facts, go ahead.
I think that if an observer saw that we spent, and I think I identified 78 pages, where either the judge or the counsel or juror 6 was asked questions, answered questions, or was talked about, showed a very in-depth inquiry, and I cited all of them, and maybe I'll read some if I have time. And I do think that the jury would also look at what Judge Giorgini did on day 5 and say, okay, he's looking at an appearance. He's not declaring that bias exists. He's not declaring prejudice. He's not declaring a Section 2 interest. But you know what? I'm going to play it safe. And I viewed it, I was there as a prophylactic step to make sure that the trial could then proceed fairly. Honestly, my colleague keeps talking about what juror 6 may or may not have shared with the other jurors in those 4 or 5 days. We didn't talk to those other jurors. We could have, but we didn't. But juror number 6 told us that he didn't recall.
Wait, Counsel, you're saying that you could have talked to the jurors?
I am absolutely saying that we could have asked the other jurors.
I think at page 11 of the January 16, 2024 transcript, you said something to the effect that we could talk to the jurors, but you said something, so it's something we'll never know. I took from the transcript that you believed, because you were counsel at the time, at the trial level, you couldn't talk to the jurors.
I believe that you couldn't get into their deliberative process, although I think I probably was wrong at the time because we weren't at the verdict stage, but I think you could have brought the other jurors in and say, what did juror say to you about the case beyond the evidence? What did he say to you? Because according to juror number 6, when we talked to him on day 5, they didn't talk about the evidence, or at least he couldn't recall it. And he said, all they know about me is that I'm friends with people in Lamb. which is what they learned on day one. And I don't recall there being a mistrial for fundamental error being raised at that point in time. If I'm wrong on the record.
Well, I don't read the question about whether, they had discussed the evidence. I think you said he responded they had not discussed the evidence. His response was just, we are still waiting on a bunch of evidence. I don't think he affirmatively answered one way or the other, because the point was raised about Rule 40. The jurors can just begin discussing the evidence immediately. And so this differs from the criminal line of cases. In that way, we have a novel approach under Rule 40, but I don't see that he answered the question that affirmatively they had not yet begun discussing the evidence.
You read your portion correctly, but above that, he's asked, number 6, have you had the opportunity to speak with your fellow jurors about anything involving this case or politics, anything like that? Actually, now I see your distinction. He said, not that I recall.
Yeah, and he did not answer affirmatively, no, not that I recall. So we're left to wondering.
If we conclude that he should not have been seated as a juror, step 2, what's the ramification of that? What kind of showing needs to be made, if any? Mr. Abney was saying that you make no showing as necessary. It's too difficult. Once you have somebody that's seated that shouldn't have been seated, that has a bias, it so infects the panel that it's I guess structural error, although he didn't say structural error, that it is a do-over. If I take it, I know you disagree, so
Okay.
What kind of showing needs to be made?
I just wanted to confirm that we do disagree, because I think that there was more questioning and more answers in this case than I've seen in many, many reported cases that did not find an abuse of discretion. I don't think Judge Giorgini engaged in abuse of discretion by seating juror number 6. So I want to be clear about
Sure.
that. So now the
But
question
assuming
is.
he did, we're just going on, I just want to go on to the next. And I'm not saying he did, but I'm just saying, assuming he did, what's the next showing that would have to be made?
Are we moving to prejudice? Because that's where I think we are, because juror 6 goes away on day 5, no question about it. And I do stand by what I said before. We heard from juror 6 about, what they did or didn't talk to, and it was not a very in-depth discussion from the court, me, or Ms. Clem's counsel. But it wasn't, that he was waxing about the virtues of Teeple or Lamb. He never said that.
He did say he had discussions, plural. He mentioned, did he just tell him that he's friends with him a bunch of times? He said discussions about them. So
To pile on for a moment too. Juror number 6 begrudgingly admitted to the degree of friendship that he had, and that's my term, because initially he just said, "Oh, we're friends." It was close friends. Then they were both interested in their campaigns. Then he donated money, and it seemed like the more you asked, the more you pressed, the more you got. And one of the concerns I have here that we're getting to on prejudice is the limited amount of information that was inquired into for the misconduct inquiry.
You both give me too much credit for bandwidth. Let me try to see if I can answer that, answer you both. I think he also later on provided more detail as well, that he really hadn't campaigned with Lamb, after the 2020 sheriff's election, and that with Teeple, with the campaign, I think he hadn't seen him for months or a year. So there's a real question about what friend means in this case. I when I was in law school, was on the moot court team, and Batson was our topic. And I remembered it then, and I'll always remember it now, that Batson wasn't interested just in the rights of the parties. Batson was interested in the rights of the excused juror. And black jurors should not be excused because of their race. And that's been expanded to other areas that are protected. Political activity under the First Amendment is protected. Now, I'm not saying we shouldn't ask juror number 6 about whether his political activity makes him impermissibly biased. But what I am saying is that you shouldn't automatically conclude that, because he has a right under the First Amendment to campaign for somebody, to make political donations, to repost a campaign Facebook page that has
Counsel,
nothing to do about the
All of
case.
this is in the context of him describing Lamb as his friend and Teeple as his close friend. So this is not an abstraction. This is not a putative potential member of the juror who's engaged in political activities, which of course I think we all agree with your point in the abstract, but he's doing these things for his friends, one who is a party and one who is the designee of the party.
But he also made clear that what he does politically has nothing to do with discharging his obligations at the trial to faithfully hear the evidence and follow the rules of the court. And he said that. This was not just a one question, one answer. I agree Judge Giorgini did that a few times, but there was a lot more colloquy with Juror 6 than that. And I think a lot more than we see in other cases. And I agree that other judges might have exercised their discretion to excuse juror number 6 right from the get-go. But Judge Giorgini, I think, did not abuse his discretion by going the other
So
way.
at what point does the relationship with a party become too close? Because really, it's not we look at what responses the prospective juror is giving, but that's not definitive. A person can honestly believe that they can be fair and impartial, but the nature of the relationship is too close for that to be trusted. So at what point is the relationship too close?
Well, I think that was answered in the Eddington case, although that was in the interest context, not in the bias or prejudice context. Somebody whose job, may be impacted depending on how they vote in a case. Somebody who works with the same agency that did the investigation. I think that this court answered that when they agreed with the Court of Appeals in Eddington that juror was Section 2 prohibited because of interest.
Well, I think in Eddington, and I could be wrong, but the person of discussion in Eddington was never seated on that jury. He was struck.
The challenge for cause was denied, but the peremptory challenge.
Right, so he never sat on the jury. Here we have a seated juror in number 6. And now we have the overlay of Rule 40 of the civil rules, where they can be discussing, evidence that's been already admitted, and so we have that as well. How does Rule 40 impact our analysis? Because this is obviously outside the criminal context. So how does Rule 40 and the fact that they can be discussing things play into this?
Well, they are supposed to discuss only the evidence, and they're supposed to do it under the circumstances provided in Rule 40H. They are not to deliberate because that's a different section of Section 40. Now, here's goes to your question about the timing, because I agree, the Eddington detective, he was struck. Now, I don't know how long he spent with the jury before he was struck, because usually we do our for cause and then we move to peremptory. I don't know, because I don't know if that's spelled out in the case. So I don't know if he had a chance to talk to the jurors, but it wasn't an issue. But my point on timing is this, that it really doesn't matter if juror number 6 didn't say anything more than what the jurors learned on day 1 in those 4 or 5 days.
But how do we know?
Because he said all they know is we're friends, and that's what he said on 1, and they all heard it on 1. On day 5, he was interviewed separately outside the presence of the other jurors. But that's what we know from the record, because nobody.
He didn't say that they were just friends. He said that he had discussions about them and that he said that he was their friend.
And I don't think the record illuminates what those discussions were, or if they were improper, or if under American power, a reasonable jury would be so impacted that the trial is prejudiced.
And you argued to the judge that you could not inquire into those discussions.
And again, at that time, I recall, and Your Honor, if the transcript says something different, I recall that my position was you could call them in to ask them what they heard, but you couldn't call them in and ask them what and again, I probably was conflating deliberation with talking about evidence at the time. I'll admit that, but I believed you could bring them in and say, what has juror 6 said to you in the last 4 days, and then analyze whether or not that would prejudice a reasonable jury to the point that we should do this mistrial now.
Here's what you said. And I don't believe it'd be proper or permissible for us to ask them about the nature of their conversations during the times they've been together in the jury room and talked about the case. So it's something we'll never know.
And that's what I'm saying now. I wouldn't have proposed we called them in and asked them what they discussed about the case. I would propose that we call and ask them what they heard from juror 6 that went beyond a discussion of the evidence. And if it's the same thing they heard on day 1 and he's let go on day 5, then then now we are in Article 6, Section 27 zone. This may have been an error, but it wasn't an error that deprived Ms. Clem of substantial justice.
Whose obligation is it to, and we're way over time, so I'm gonna, but
I'm seeing that.
regardless.
I've got one more question.
I know, you've got a question. I'm gonna, just a quick follow-up. Whose obligation is it to ask the judge to make the inquiry of the jurors?
I think that the person who is making the motion for mistrial bears the burden to show that there are facts that support a mistrial. And I think that the denial of a mistrial is viewed through an abuse of discretion and not the de novo standard, as my colleague thinks.
Justice Montgomery?
So if it's your position that a prejudice showing is necessary, and for whatever reason, the plaintiffs were unable to inquire to establish prejudice, what do we do?
Well, I think you do what you did, I think, de facto in Eddington. So in Eddington, you all looked at that juror and said, he's interested. No way should he be on the panel. But you affirmed in all respects the Court of Appeals decision, which said that even though this juror should have never, ever been on the panel, we can't find prejudice, so we're not going to order a new trial be held.
Right, and again, Eddington, in a criminal case, there were no deliberations. Here in a civil case, there were discussions. We know there were discussions, but the plaintiff was unable for whatever reason, either because everybody misunderstood the impact of 606 or the nature of misconduct inquiry, couldn't inquire into it. Therefore, it's not that we'll never know. Under the circumstances, we don't know. So what do we do with that?
Well, I think you have to take the record for what it is. Because
And if we find the record then insufficient because the parties were unable to inquire as they should have,
well,
do we find the judge then abused discretion because they misapplied the law?
respectfully, Your Honor, and I know that Justice Lopez will correct me if I'm wrong about what I'm about to say, and I appreciate that, but I don't recall the plaintiff asking for the other jurors to be brought in to ask them what juror 6 may or may not have told them that went beyond any discussion of the evidence. And I think that's the problem, is at the end of the day, it's indisputable that a jury that was not challenged as being unfair or impartial is the jury that deliberated and decided the case. And that, I said it before and I'll say it again, that takes you back into Article 6, Section 27 zone, and the Constitution rules us all. If you can't show the prejudice, if you can't show it through in actuality or through the analytical framework of American power, then you cannot say that either the Court of Appeals was wrong in saying no new trial here. There should be no new trial here. This verdict, the jury that deliberated worked hard. They were fair.
I think I've allowed you a lot of time. So are there any further questions? And if not, thank you.
And thank you.
Mr. Abney. And while you're walking 2 feet away, could you address the last point that we were just discussing? I mean, in my view, it might have been a misunderstanding about the ability to ask the jurors what, if any, extraneous matters have been brought to their attention, but isn't it your burden to ask the court to engage in that discussion? And I didn't see that your colleague asked. So what do we do with that?
Well, what you do with it is say, number one, it doesn't much matter because there is a severe appearance of impropriety, gross appearance of impropriety, so there never should have been the trial. The trial should have stopped. As soon as that guy gets on the panel and everything goes forward for a couple of days, there's no chance. The appearance of impropriety is extreme. Should one side have said, I want more of an inquiry? Probably. But then again, you asked, I thought it was a very good question that whose obligation is it to ask the judge to make an inquiry, which is basically what you said with a little more embellishment. I think it's every lawyer's obligation, whether you're on the plaintiff side, defense side, to make sure that there is a fair and impartial jury. And so if you get an inkling on the other side that there's something wrong here, you have an obligation to the judicial system to come forward and say, we need to ask some more questions. Just before the Civil War, Abraham Lincoln said, the world has never had a good definition of the word liberty, and right now we are much in need of one. Well, the world has never had a good definition of rehabilitation, and right now we are definitely very much in need of one. So whatever the court does, I hope that there will actually be finally a definition of what rehabilitation means, because right now we don't have one. And that leads me to my fictional example of rehabilitation. A very rapacious businessman changes from that into one of the kindest, most charitable men on the planet. His name was Ebenezer Scrooge, of course. But he was visited by Jacob Marley and three ghosts, and it took all night long to get him to be rehabilitated. You don't have that much time when you're dealing with a jury. Thank you, Hunter.
Thank you. Okay, thank both counsel for your today and your briefing on the matter. We'll take the matter under advisement and issue a ruling in due course. We stand adjourned.